So, welcome to Intellectual Property Class 5, in which I'm going to provide a general introduction to patents, how patent law is kind of conceptualized and worked, how you obtain a patent, and probably most importantly, what a patent document actually looks like, and kind of hone in on some of the important elements of a patent document. So as we've discussed in our previous classes, right, intellectual property or intangible rights or rather exclusive rights in intangible goods can have many different sources. One of those sources is constitutional, and patents are one of the two forms of intellectual property right that are based on the Constitution, right? So both patent and copyright are provided for by the United States Constitution, or rather, the United States Constitution says that Congress has the power to create patent and copyright protection if it wants to. And as a consequence of that constitutional power granted to Congress, patents and copyrights are, broadly speaking, exclusively federal rights. Now, patents are definitely exclusively federal rights. There's no such thing as a state law-based patent. Copyrights are mostly exclusively federal rights, and we'll touch a little bit on ways in which arguably there are forms of non-federal copyright protection. But for the purpose of patents are 100% federal rights, and the intellectual property clause is what gave Congress the authority to create them in the first place. And specifically, the intellectual property clause has been read by the Supreme Court, as we say, in parallel. Right? So you'll see that the clause says that Congress has the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right in their respective writings and discoveries. So which aspects of the intellectual property clause authorize Congress to create patents? Well, to promote the progress of useful arts by securing for limited times to inventors the exclusive right to their discoveries. And this is an important thing to recognize because it reflects the way the language was used in the late 18th century when the Constitution and when Article 1, Section 8, Clause 8 were drafted. Right. So in kind of 18th century parlance, when you talked about the progress of science, you were talking about knowledge. Right? And copyright was intended to provide an incentive to generate knowledge. By contrast, useful arts are like the mechanical arts, as it were. And so useful arts was understood to go to inventions and discoveries, right? So promoting the progress of useful arts went to patent protection. It was the way that Congress could provide an incentive for inventors to invest in innovation and the discovery of new technical ways of accomplishing different goals. Okay, well, again, let's return to our theories of intellectual property that we've talked about earlier. How should we think about the justification for different forms of intellectual property? Typically, patent protection, the protection of new ideas, right, of inventions and discoveries, is seen as largely consequentialist, utilitarian, having essentially an economic basis. In other words, sort of the justificatory ideas we've discussed previously in the class in relation to intellectual property protection for the purpose of advancing the public welfare, right, and for the purpose of advancing the net welfare of the consumer, is really seen as being typically the primary justification for patent protection. Of course, people still give patent protection certain forms of moral valence anyway, right? So many people look to the justification of patent protection not only in the kind of utilitarian or economic goals, right? Subsidizing innovation, right? The cost to the public is lower than the benefit from the additional innovation incentivized by patent protection. Many people also see kind of a moral value to that as well, kind of fruits of the labor of the inventor theory of patent protection as well. As I've mentioned, right, lots of different ways of obtaining intellectual property rights. We previously talked about trade secrets. How do you get a trade secret? Well, you just come into possession or develop confidential information and maintain the confidentiality of that information, right? By contrast, copyright, how do you obtain a copyright? All you have to do is generate an original work of authorship. If you create an original work of authorship and fix it in a tangible medium, in other words, make a copy of that original work of authorship, you get copyright protection automatically. Right? Now, you can register a copyright with the Copyright Office, but you're not obligated to, and you own the copyright whether or not you've registered. Now, we'll talk about registration of copyrights later. There are a lot of good reasons to register, but it's not obligatory in order to get a copyright in the first place. Likewise, with trademark protection, the only thing you have to do in order to own a trademark is use a distinctive mark in commerce. As soon as you start using the distinctive mark in a way that conveys information to consumers about the source of a good or service, presto, you own a trademark in that distinctive mark that you're using in commerce. Again, you can register trademarks with the Patent and Trademark Office, but you're not obligated to, and you can even enforce trademarks that you haven't registered at all, right? So trademark protection comes into existence merely by virtue of using the mark in question. Similarly, the right of publicity, which we'll talk about toward the end of the class, is a kind of property right in the name and likeness of a famous individual. How does a right of publicity come into existence? Well, it's very straightforward. Just become a celebrity and automatically you get a right of publicity. Now, of course, obviously easier said than done. Becoming a celebrity can be a bit of an uphill struggle, right? But you don't have to do anything to get a right of publicity. It comes into existence automatically. Patents are different, right? In order to get a patent, unlike all those other forms of intellectual property, you actually have to apply to the government to get the patent. The only way you can own a patent is if you send an application to the Patent and Trademark Office, they examine your patent application, and they grant you the patent. So one way I like to encourage people to think about this is that for all those other forms of intellectual property, trade secret protection, copyright protection, trademark protection, right of publicity protection, none of those are verbs, right? In other words, you can't copyright something, but you can register it, right? You can't trademark something, but you can register a distinctive mark, right? You can't generate a right of publicity or a trade secret on its own, right? It's protected by virtue of what you do with it, not the way you apply or register it with the government. In other words, the government isn't creating the subject matter of trade secret, copyright, trademark, and right of publicity. It's just offering certain kinds of exclusive rights to the people who do create those things. By contrast, the government does create patents. So patent is a verb in a way that trade secret, copyright, trademark, and right of publicity aren't, because you can patent an idea by applying for a patent with the PTO, going through the application process, through the patent prosecution process, and convincing the PTO to grant the patent for which you applied. Now, there's multiple different kinds of patents. Typically, when we think about patent protection, we think about utility patents, and utility patents protect new and useful inventions and discoveries. So that's the classic form of patent. And what utility patents ultimately do is claim in the form of specific patent claims enumerated in the patent document. So the core element, the element of a patent document that defines the scope of protection is the patent claim or patent claims, and those will come at the end of the patent document. We'll look at what those look like in a minute. But there's not the only kind of patent, right? There's also design patents, and design patents claim, or rather protect, new ornamental designs. And unlike utility patent claims, which claim in words, design patents claim in pictures. Right? So the claim of a design patent is claimed by the image that constitutes the subject matter of the design patent itself. And we'll be looking at design patents later in this class as well. And then finally, we're not going to spend a lot of time with it, but plant patents are kind of at least arguably a form of patent protection as well. And what they do is they protect new forms of plant varieties. Some people think about them somewhat differently than patents in the traditional sense. And in fact, the name for them in other intellectual property systems, and especially in Europe, is somewhat different. But all you need to know for the purpose of this class is that it's at least possible, and in fact quite common, for people to obtain exclusive rights over new plant varieties that they've developed. And they do so through the plant patent system. Okay, so what are the requirements of a utility patent? Like, what do you have to do in order to get a utility patent? Well, there's 5 substantive requirements. First off, you got to provide adequate support for the patent that you want to get, right? In other words, you actually have to tell the government, at least in theory, how the invention or discovery works, and provide enough information that a person looking at the patent document would be able to realize that invention or discovery based on what you've disclosed in the patent. In addition, you've got to be applying for a patent in something that's the kind of thing that you can patent. So under Section 101 of the Patent Act, right, the statute provides for the scope of what can actually potentially be patented in the first place. We'll talk about this extensively in future classes. But essentially, certain kinds of things are set apart from what can actually be patented. Specifically, you can't obtain a patent, for example, in a law of nature, right? Or often in certain cases in mathematical formula may or may not be, typically or not, may sometimes be patentable, right? But laws of nature or kind of facts about the world can't be the subject of patent protection. Likewise, things that are too abstract can't be the subject of patent protection either. There's a lot of debate over exactly what that means, and we'll try to dig into that more later in the class and figure out, to the best of our ability, sort of how the Supreme Court has thought about the scope of what falls inside and outside what you can get a patent on in the first place. But then the 3 key substantive requirements for patentability are usefulness, novelty, and non-obviousness. So usefulness is a pretty low bar. Essentially, you can only get a patent on an invention or discovery if it's good for something. But it can be good for just about anything. Any kind of use whatsoever is going to be sufficient to justify potential patent protection, right? So you have to be able to do something with it. You have to disclose something that the invention or discovery is good for, right? But it's defined very broadly, right? A lot of different things can satisfy the usefulness requirement. The core requirement, the most fundamental requirement for patent protection is novelty, right? That means you can only get a patent over something that's new. And the Supreme Court has actually said that that's a constitutional requirement. It would be unconstitutional for Congress to extend patent protection over inventions or discoveries that aren't novel, that aren't new inventions or discoveries. And in fact, well, if they're not new, they're not really inventions or discoveries at all, because people already know about them. And novelty really gets at something fundamental about the nature of patent protection, which is that the idea behind patent protection, or at least one of the ideas behind patent protection, is not only to encourage investment in innovation, in the pursuit of inventions and discoveries, but also to encourage disclosure, right? So at least part of the idea behind patent protection is that patents require patent applicants to disclose the inventions or discoveries that they've developed in order to receive exclusive rights in the first place. And compare that to the alternative, which in many cases is a trade secret, right? So when an inventor is considering how to pursue maintaining exclusive rights in their inventions or discoveries, in many cases they have an option, right? They can either pursue trade secret protection. In other words, they can keep the information secret and not disclose it and use it in a secret fashion, right? And rely on maintaining that confidentiality in order to have exclusive rights. Or they can go the other route and apply for patent protection, which requires disclosure, but then provides the patent applicant or the patent owner, if their application is successful, with exclusive rights for a period of time, a maximum of 20 years, broadly speaking, right? So you've got 2 choices. You can either pursue trade secret protection, which is potentially indefinite in time. It's potentially perpetual protection so long as you maintain the secret, right? But you have to be able to keep it secret. Certain kinds of things you can't maintain the secrecy, right? If your invention or discovery could be reverse engineered, well, trade secret protection probably isn't going to do a whole lot of good because your competitors are going to be able to figure it out. Then it won't be a secret anymore, right? Certain kinds of things. In addition, it's hard to keep them secret, right? Because you need to be able to share them more broadly. And patent protection enables that broad sharing because a patent provides exclusive rights in a claimed invention or discovery as against the entire world, right? So you don't have to maintain secrecy. In fact, you're obligated to make the invention or discovery public in order to claim a patent in that invention or discovery in the first place. And then finally, the last requirement for a utility patent is related to the novelty requirement, but it's known as non-obviousness, right? So certain kinds of inventions or discoveries might be technically new, but so obvious that they don't seem like they ought to be the subject for patent protection. So maybe think back, for example, to the suck cut and the Flowbee that we talked about in a previous class, right? Now, technically speaking, when the Flowbee was invented, it combined two things that hadn't been combined before, right? So sucking and cutting, right? The vacuum cleaner and the hair clippers. Now that was new, right? People hadn't done that before. Maybe it was too obvious, right? Maybe it was too obvious for patent protection. Maybe not, right? Depends on where we want to set the bar for obviousness in relation to patent protection, right? Some people think the bar should be set high, right? In other words, you've got to come up with a really significant new invention. Other people think the bar to be set low, right? As long as somebody hasn't done it before, well, then presumably it wasn't obvious, right? I mean, if it was obvious, somebody would have done it. Therefore, if somebody didn't do it, then it wasn't obvious, QED, right? Should we think about obviousness in that way? That makes it a pretty easy hurdle to clear. So an interesting policy question to think about, how hard we want to make it to get patent protection. And that bar has been set at different places over the years, right? The Supreme Court has, on some occasions, set the bar quite low. On other cases, it's really put a higher expectation on patent applicants, requiring like a flash of genius, for example, in order for a patent to issue in the first place. Okay, so as a practical matter, what do you do in order to go about getting a patent, or as we call it, prosecuting a patent, right? So the process of applying for a patent is known as patent prosecutors. And in order to be a patent prosecutor, you have to be a member of the patent bar, right? So there's a special federal bar that enables people to become patent prosecutors and to assist inventors with obtaining a patent. And in order to become a member of the patent bar, you have to satisfy certain requirements. Essentially, you have to have a science degree, an undergraduate science degree of one kind or another. And there's very explicit requirements that are provided by the patent bar as to who can qualify and who doesn't. And you have to take the patent bar, which is a special exam like the bar exam, but different, that's provided for people who want to be patent prosecutors. Now, mind you, the patent bar is only for patent prosecution. In other words, only for representing people before the USPTO, right? It's not for people who represent patent owners in litigation, right? So you don't have to be a member of the patent bar to litigate a patent. You only have to be a member of the patent bar to prosecute a patent. Okay, so how does this work? Well, you send in the application will go to an examiner, and the examiner will look at the patent document and determine whether or not a patent should issue based on the application in question. Very frequently, probably most of the time, the patent examiner will go back to the patent applicant and point out certain problems with the patent application and give the patent applicant an opportunity to correct them. Ultimately, there can be a back and forth between the patent applicant and the patent examiner as they negotiate what the patent is actually claiming, the scope of the claims, what kind of disclosures are required, so on and so forth. And then ultimately the patent examiner will decide to either grant or deny the patent application. If the application is denied, if the patent application is rejected, the applicant then has the ability to appeal up the line. Right? So they can do it administratively within the patent office itself by appealing the rejection to the Patent Trial and Appeal Board. They can also appeal from there up to the Federal Circuit, which is the federal court that has jurisdiction to hear patent appeals, among some other things. But the primary purpose is to provide a kind of one-stop shop for patent cases, as it were. And then finally, all the way up to the Supreme Court. Now, there are many other administrative procedures related to patent applications that have been developed in recent years. You may have potentially heard of things like inter partes review and so on and so forth. Essentially, in some cases, third parties can challenge the granting of a patent on the ground that, well, it's either defective in some way or the patent examiner missed something. Typically, it would be competitors or people working in the same market who don't want to see the patent issue because it will prevent them from doing something that they want to do or limit their access to the market in which they're working. Okay, so let's assume the patent issues. The patent owner litigates on a patent. What can they get as a result? Well, in the case of patent protection, you can get both damages and an injunction, or potentially and an injunction. In other words, the patent owner can get compensated for the economic harm that they suffered as a function of infringement. They can also prevent the infringer from continuing to infringe in the future. Both of these can be really valuable remedies in different kinds of ways. And we'll talk about patent and other forms of IP remedies later in this class. Okay, so what does a patent document actually look like? Well, here's one that's provided in the casebook, and you'll see that the patent document has lots of different elements, right? It starts at the top with the name of the inventor, right? So Hoting et al., that's the name of the inventor of the particular invention or discovery in question. And then you'll see on the top right a patent number and the date of the patent. So patents are issued sequentially, right? There are millions and millions and millions of utility patents that have issued, but there are also a lot of design patents and plant patents that have been issued as well. And you can tell the difference because a utility patent just has a number. A design patent will have the letter D associated with it as well. So if you see the D along with the patent number, that means you're dealing with the design patent, not a utility patent. You need to think about them differently. As we'll talk about later in the class, utility patents and design patents are really different in really important ways. So make sure you don't confuse them, right? Because if you apply the law of utility patents to design patents and vice versa, you're very likely to be wrong, right? So please don't do that. Make sure you know what kind of patent you are talking about. You're then going to see the date on which the patent has issued. And then looking at the left, you can see the names of the inventors, right? Patents can only issue to the person who actually, a person or persons who actually invented the claimed invention or discovery, right? So the actual inventor always has to be on the patent applicant. However, and this is very frequently the case, the inventors can assign the patent to someone else. So here the assignee is Bang Zoomed into Design out of nearby Cincinnati, Ohio. Okay, you can see a lot more technical information. One of the things I want you to focus on are references cited. What do we mean by that? That's what we call prior art, right? So what's the main thing that a patent examiner is going to do when they're evaluating whether or not a patent could issue? Well, they're going to look back to see what other kinds of inventions or discoveries are in the same area in order to determine whether and to what extent the claimed invention or discovery is actually new, right? So this is part of the novelty analysis. And what's one of the best ways of figuring out what's been done and what hasn't? Well, they go back to the backlog of all of these other patent applications or all these other patents that have been granted, right? So you can see in this list of references cited a whole bunch of different patents listed that are similar to the patent in question. And you'll note some of them are utility patents. In other words, they're just the number, like 153159 or 216530. Others are design patents, right? So D 243, 500, et cetera, that's a design patent. So it's going to be different from a utility patent. And you want to make sure to distinguish between the utility patents and the design patents in terms of where you're going to look for them and how they're going to work. Okay, then you can see the abstract on the right. It's basically a kind of a basic description of the nature of the invention in question. So a measuring cup has at least one ramp formed in relief radially inwardly on the inside surface of the measuring cup sidewall, et cetera, et cetera, et cetera. That's important. Here you can see a drawing of the invention, right? But because this is a utility patent, the drawing is not the claim itself. Unlike a design patent, where the drawing would be the claim, in a utility patent, the drawing is illustrating the claim. In other words, it's an example of what the claim is. Okay, so what is the claim itself? Well, here's the realization of the patented invention. Is that the claim? No, that's not the claim either. What's the claim? The claim is this, right? The 732 patent claims a measuring device comprising a bottom wall and a generally vertical and encircling sidewall having a lower edge and an upper edge, said sidewall defining an upwardly opening cup with an upper end, a spout attached integrally to said sidewall, and a pair of continuously sloping ramps formed integrally with and radially inward in relief from said sidewall, et cetera, et cetera, et cetera. We're going to talk about this patent claim more in our discussion, but what I'd like you to do before class is actually read through the patent claim itself and try to start putting it into English. In other words, what is the patent claim actually claiming, right? Because the patent claim defines the metes and bounds of the property interest that's granted by the patent document. So in order to understand what the patent owner actually owns, we need to know what the patent claim actually says. So I want you to spend some time sitting down and reading it carefully to figure out what's actually being claimed in this patent, and think about comparing it to both the realization of the measuring cup and the drawing of the measuring cup represented in the patent document itself. And we're going to return to have that conversation tomorrow.